With the increased use of cell phones and social media, more and more people are becoming vulnerable to cyberbullying and sexualized cyberbullying. Unfortunately, the law does not yet have an effective or uniform response to these problems. In this video, we're going to talk about a few things which might be helpful to victims of cyberbullying, with a focus on sexualized cyberbullying. Cyberbullying is a broad term that covers a range of emotional and verbal abuse which takes place on the internet. Unlike traditional bullying, the victim and the abuser or bully don't have to be in the same place at the same time. So victims, in particular young people who are highly connected to the internet and social media, have a really difficult time escaping a cyberbully. The nature of the internet is also problematic because the content remains there indefinitely. Sexualized cyberbullying is essentially the sharing of intimate images without consent. Sometimes it's called revenge porn, or sexting if the person in the photo no longer consents to the sharing of the image. Two examples of tragedies that arose from sexualized cyberbullying are the deaths of Amanda Todd and Rehtaeh Parsons, who were young women who killed themselves after sexualized cyberbullying went out of control. If you've been the victim of sexualized cyberbullying, there are a number of avenues that you can explore in terms of bringing a lawsuit. Across Canada, it would be open to someone to bring a claim in defamation or for the intentional infliction of mental suffering. It's possible, depending on the underlying circumstance, that you might be able to bring a claim in assault. A civil case for assault is different than a criminal case, whereas in the civil sense, the touching does not have to have happened yet. If the cyberbullying or sexualized cyberbullying causes you to believe that the unwanted touching is about to happen, then you might have an assault case. Certain provinces also have legislation that might be useful for bringing a claim. In particular, in British Columbia, there is privacy legislation that creates a tort for invasion of privacy. And in Nova Scotia, there used to be the Cyber Safety Act, although that has recently been struck down. The Cyber Safety Act creates a tort for cyberbullying, and it's not yet clear whether or not the decision striking it down is going to be appealed. The responsibility of schools for cyberbullying, and in particular sexualized cyberbullying, varies depending on the province. There are some provinces, including Ontario, Manitoba, Quebec, Nova Scotia, among others, where schools have legislation that govern student conduct, including things such as cyberbullying or sexualized cyberbullying. In some places, the codes of conduct and the policies may actually govern behavior that takes place off campus as well. So even if the bullying is happening outside of a school, students should look into the codes of conduct and see exactly what they say. The responsibility of the school is to ensure that it has a policy in place and a means of addressing cyberbullying promptly and effectively. And this should help protect the school and the board against possible liability. Students, on their part, if they are the victims of cyberbullying, should consider whether there may be a case of negligence against their school or their board. As society continues to gain a fuller appreciation of the harms caused by cyberbullying, and in particular sexualized cyberbullying, we can expect that the number of civil cases based on these facts will continue to rise. Access to justice for the victims requires developments in concurrent areas of law as well, in particular with respect to the protection of their privacy. Over time, we can hope that all of these changes will contribute to developing an effective recourse for victims.